The Justice Yashwant Varma case, where crores in unaccounted cash were reportedly recovered from his official residence in Delhi, has now reached a new turning point. The Lok Sabha Inquiry Committee has tabled its report. The findings hold that the charges are proved, the cash was unexplained, evidence at the scene was disrupted. Justice Varma could not offer a satisfactory explanation. But Justice Varma had already resigned earlier this year, which means the impeachment motion against him is now legally infructuous. So the question is, what happens now? Can an FIR still be registered? Is there any criminal accountability left to pursue, or does this entire process end here without any consequences? To discuss this, we are joined by Advocate Mathews, who was among the first and a long time only one to demand registration of an FIR in the case, at a time where much of the bar stayed silent. Thank you so much, sir, to join us.
Thank you. Yeah.
I think this is the rarest case where we will be mirroring, the Indian judicial system will be mirroring itself. So my first question for you is very common, which is the first intents come in our mind. Can an FIR be registered now?
The FIR should have been registered the moment the money was recovered. The incident was brought to the notice of the police. The police, there was no business for the police to even wait for the permission of the Chief Justice. The permission may be required for prosecution. Registration means, FIR means first information report.
Exactly.
And even to seek the permission of the Chief Justice of India, assuming such a permission is required, then there should be a first information report, based on which alone permission can be sought. Seeking the permission of the Chief Justice of India is absolutely ridiculous. This is a product of online reference in the German in Veerasamy by the FIR Constitutional Bench. The criminal laws apply equally to all the people of this country. The courts have no business to legislate. Courts have no power to legislate. But the courts have been legislating for a pretty long time. And you must understand, when a parliament, I repeat every time, when a parliament enacts a law, we are all symbolically present. Yeah. It is with our consent a law is enacted. It is binds all. Record of a parliament binds all. On the contrary, record of a court binds only the parties. A judgment in a case between A and B will bind A and B only, and not C and D, who are not parties. So there's a basic jurisprudence. The lawyers in this country, I'm afraid to say, if they do not know the concept of res judicata and the related concept, just opposite, res inter alios.
Okay.
The doctrine of res inter alios means you are not bound by a judgment of which you are not a party. The full maxim is res inter alios acta altori nocere non debet. So judgments of the Supreme Court are not the law of the land. So if in a case between A and B, if the Supreme Court may involve some principle where none existed, or follows a principle which has in existence, that principle, that is the reason for the judgment, ratio decidendi, will be applicable as a binding precedent in a subsequent case. So law enacted by the Supreme Court is one thing, and the precedent is different. Nobody has a quarrel about precedent. But unfortunately, there is not a single precedent in the last 75 years the Supreme Court has evolved, except for the nonsense called basic structure theory and a continuous mandamus. The basic structure theory, it is little academic, little lawyers may not understand it. Basic structure theory says the absurdity of the basic structure theory can be established in 2 or 3 sentences. Prior to Kesavananda Bharati, if you go to a court and invoke Article 32, the honorable judges would ask me, Mr. Nedumpara, why are you here? I must say that my liberty is infringed, my rights are infringed, my fundamental rights are infringed. Otherwise, I cannot go. After Kesavananda Bharati, many of my friends, PIN Walas, industry, they go to the Supreme Court and say, my lords, none of my rights are infringed, but the basic structure is infringed. But no judge would ever ask the PIN petitioner that if none of your rights are infringed, That means you have no suffered no legal injury. Then how does it matter to you if the basic structure is absolutely crushed, reduced to rubbles? But if your actual grievance is that your rights are infringed, tell me which right is infringed. Your freedom of speech, your liberty, your right to freedom of faith, what right is infringed? You tell me that. So basic structure theory is I would say, use a strong expression and nonsense, which empower people, busybodies to enter the courts, the Article 32. And look here, how Article 32 is about in abuse. Article nowhere in the world the Supreme Court is the first court of original jurisdiction. Our founding fathers created such a avenue for the violation of grave fundamental rights. Somebody is in jail. If suppose I am in jail, I am a poor man. You, Mahima, can move the Supreme Court, invoke Article 32. There, I am the petitioner. You are only representing me, acting pro bono. That is a pro bono litigation. I am in complete support of that. Today, there is no pro bono litigation in enforcement of a fundamental right of a man who, out of his poverty, illiteracy, and like reasons, is unable to go to a court. Today, we have only petitions which are of political nature for name, fame, and money. So completely has been abused. So you may ask me, when I went to the Supreme Court asking for a registration of FIR in Justice Varma's case, did I not act as a public interest litigant? No, there's a difference. So there is a difference. See, the concept of, you must have heard hue and cry. The word comes from where? Under the English law, where every citizen, every subject is under duty to report to the police, the king, any crime. Every crime is against the peace of the king. So there's a duty. If you have seen a murder taking place or any kind of offense, theft, anything, then you are under a duty to report it, and you are under a duty to apprehend also. That's why a private person can apprehend a criminal.
So the simple answer to my question will be that it will not need a prior we say sanction requirement under Veeraswamy judgment, that people say that.
Veeraswamy judgment is absurd. It's a peringurium. It has to be ignored. And that political, that kind of, see the constitutional democracy, the judicial in its domain is independent, sovereign. Nobody can enter. But the police in its domain, that is, investigation of crimes, bringing the offenders in the book, that is a sovereign, the duty of the police, sovereign function, police function is police, and the court cannot interfere. Courts have no jurisdiction to interfere. In the constitutional democracy, it is not the judiciary alone is independent. The police, the parliament, and other wings of the state are independent as much as judiciary. So the court judiciary can interfere where the court police acts without any jurisdiction. The Supreme Court has well explained the reasons where no offense is made of.
So
suppose a crime is registered against me for believing in the Christian faith. I can say no offense is made of. Police are right to
so any citizen is free to register an FIR against this case?
Yes. And I had to move the Supreme Court because I need only have to go to the police station. I need only to return to the Home Minister of the police, which I did. But see, because in view of the judgment of the Supreme Court, in Veeraswamy's case, where without any discussion, an ipse dixit, like the better word is ex cathedra statement. Ex cathedra statement belongs that come from the Pope. Supreme Court from the thin air says, as if from the board from the blue says, no FIR can be registered. And it's unfortunate in this country, the legal fraternity has not raised this issue. The press, there is, I find it difficult to believe. We still live in a constitutional democracy where the judges can claim immunity from criminal offences. I know a case where there is the allegation of an FIR registered involving a POSCO offence. And a little known correspondent brought me the FIR to me. The name of the accused was a judge, sitting judge, which court I wrote there was now. Then I also did not do anything further because I have limitation. I am a practicing lawyer.
Yes,
I cannot
yes,
make
yes.
every judge in this country, hostile to me. So, say some judges, in fact, when this is Varma's case I took up, some judges call me, sitting judges call me and said, Nedumpara, you are doing the right thing. So there are good judges. There are conscientious judges. And only thing that even the conscientious judges sitting and retired, they refuse to speak. Because the problem with this, see, I tell you, I'm from Kerala. I know Justice K.G. Balakrishnan, even before he became a judge. He became a judge in 84. 84, I am a lawyer. So, but I wrote against him for investigation of his corruption allegations against him. But that leads to strain of relationship.
Yeah.
So therefore, when the problem with the lawyers is that, we are lawyers and judges. See, we know all each other. See, I'm 68 now. See, whoever I was a judge now, we both unite to me in the members of the bar. So we know each other. It's very difficult to, you say something which will be, you say something against you, somebody who is very personally known. So therefore, I'm able to speak now because I don't have any obligation to anybody. I've not sought any favor from anybody. I don't have any obligations to anybody. So that is what most people have. Say, somebody become a judge or the High Court. Say, he occupied that office. He has some godfathers.
Yeah.
Or people don't want it to, strain the relationship. So they privately talk. And therefore, many righteous judges, I will not disclose the names, but at least two judges, sitting judges of two different high courts, called me and said, Nedumpara, you're doing the right thing. And so that was something that came as a motivation.
Exactly.
On the contrary, Kapil Sibal and all, they are glorifying a judge.
Yeah, how you see that? You also saw the press conference where.
Look here, see, there is a problem with the bar is we don't have a leader in the bar. Who is a leader? Kapil Sibal, nothing personal against him. See, when the standard 8 book came, that issue, textbook issue came,
Exactly.
he and Abhishek Manu Singhvi, they went to the Chief Justice. And that, what happened?
Okay.
That book was banished.
Okay.
And now the other day, Vikas Singh,
Yeah.
the president of the Supreme Court Bar Association, he went and told the Chief Justice, some PL, how this PL comes. Yeah. Then the Supreme Chief Justice passed an order that since henceforth nobody shall circulate video clippings, etc., etc., etc. Complete gag. And nobody in this country has reacted.
Yeah.
Where is the mainstream media? Nobody. Nobody has. So
Later, the clarification came that it was not for journalism and stuff like that.
No. What is that? See, what is that print media? That social media, can you ban it? See, we live in a constitutional democracy. Whatever happens in the seat of justice, the public has a right to know.
Exactly.
So we have a right to know. If you have a right to know, we have a right to circulate it. See, suppose I manipulate the videos, write something, then see there is a law.
I'll just I will please.
Yeah.
I'll just back to the topic, and I'll come to the second question, which is the committee stopped the shot of attributing ownership to the cash directly to Justice Varma. It only called it unexplained. Is that a legal loophole that could shield him from accountability?
No, let's say, forgive me, don't think I'm a very arrogant person. Consider that I alone knows laws. Even at the cost of being be accused of that. See, the basic distinction between investigation and inquiry and adjudication is lost sight of. Who can investigate?
Yeah.
So, a retired Supreme Court judge or sitting Supreme Court judge cannot investigate. Investigation is the job of the policeman. Collection of evidence. What is the investigation by that committee appointed by Chief Justice Khanna and the present committee constituted by the Speaker? These are all civil nature. The civil nature, real investigation is to be done by the policeman. He alone can investigate. The investigation, inquiry, and adjudication. You remember in NEET case, I had a clash with the Chief Justice Chandrachud.
Okay.
There, see, when a question paper leak, who has to investigate? The investigation has to be the police.
Yeah.
Supreme Court cannot conduct the investigation. Inquiry, investigation, and adjudication are different. Now, court is into everything under the sun. Now, the court claims its jurisdiction. And why? Because there is a dynasties who profit out of they have made a legal professional industry, very profitable industry, a face value jurisdiction, and they make some people say they could make ₹1 crore as fees per day, and Article 32 has been the private, is a I should say exclusive province of a few lawyers. One of the Article 32 petitions are dismissed. How many Article petitions? Article 32 maybe less than 1,000 petitions are instituted. Is there any petition of a common man for the enforcement of his fundamental right ever entertained? No. Or is the Supreme Court is primarily a final court of appeal, and our petitions under Article 136, especially petitions are dismissed in 93 seconds and even less. So the whole institution is captured by a few people.
So how will you read the panel's language in this case, and how you see the case will be moving forward?
See, with the Varma, Justice Varma, I refuse to call him justice. Anyway, I had a little controversy with the Justice Khanna when I said Varma. He is not Justice Varma. How can he call him a Justice Varma? Anyway, I called it Justice Varma. See, with his resignation, everything has come to end. There is nothing like a resignation being accepted. That controversy came.
Yeah.
There is one 1978 German, I don't exactly remember the cause title. 1978, Fidget Constitution, Fidget Constitution, then
along the acceptance.
So there is no need of acceptance.
Yeah.
And I remember this issue very particularly because in Kerala, the exact year I don't remember, maybe 2000 or 1998, like that. Then Justice Dandapani. Justice Dandapani was elevated to Kerala High Court. And then his wife was practicing law. Even today, I believe she is practicing. So then he was transferred to another High Court. So Justice Dandapani was reluctant to move out. And then he tendered a resignation. And later I think he had a, second thoughts on that.
Yeah.
Then there was the petition was filed.
Yeah.
And the Kerala High Court, I believe there's the Chief Justice Balakrishnan, who was then the judge of the Kerala High Court, held against Justice Dandapani. Once you tender a resignation, then the resignation, there's no question of acceptance. It come into immediate effect. Article 217, I think. Let me say 1 second. Article 217 of the Constitution. Yes. Yeah. Okay. Let me check. That says that with a judge can resign by tendering yes. Understood yes. Okay. Yes. Then Article 271, I believe. I check it because it's taking time. Yes. So a judge can make a submit a resignation, and the resignation, the moment he submits a resignation, it is, there's no question of any acceptance. So the impeachment proceedings has come to an end. It has become infructuous. The committee's report is only academic value now.
Exactly.
Nothing more. The committee's report cannot be used for prosecuting him, for which investigation has to be conducted by the police. And then he retired, he resigned. So he is entitled to all pension and other benefits.
Yeah, exactly.
So therefore, nothing. Unless there is a law to prevent him from drawing the pension and other benefits, he is entitled. So no, he is.
He will be.
He is entitled to. Yes, please.
Yeah,
please.
he is entitled to the pension and other benefit.
Yes.
Yeah. So there will be no accountability to the case. And being proved.
No, a case can have two consequences.
Yes.
One is criminal consequences,
Yes.
for which an FIR has to be registered. I will
Yeah.
move an FIR now. Yes, because say, I have nothing against Justice Varma, because I was little hesitant to move another petition to move again to take up the issue, because people should not misunderstand as something against the person against Justice Varma. I have nothing against him. But something I know more than about. See, after this matter came, I came across a number of judgments of him involving even escorts and all. So that are very, very questionable. This is, we as lawyers, when we read a judgment, we understand many things.
So will you be moving forward with the FIR?
That certainly yes. Certainly yes. Not because I have anything personally against, but we know many cases of corruption.
Yeah.
But we cannot utter a word. Utter a word, you see, because there is a law of contempt and law of defamation. And you must remember that there is an instance when this Justice P.V. Saman's photo was flashed for 15 seconds that led to a suit being filed for 100 crores, and it was decreed in no time by the Pune court. And 20 crore was made to be in appeal to admit an appeal. 20 crore was made to be deposited and the bank guarantee for the entire amount, if my memory is right.
Okay.
So therefore, we have a law of defamation and we have a law of contempt.
Yes.
So we cannot say anything. So I believe the time has come. The law of contempt all should go. We are a free society. See, the law of contempt comes from where? It's a cathartic jurisdiction.
Exactly.
Cathartic means belongs to the dark ages.
True.
It is under the common law, the guilt against a man has to be proved by other men and means. There's a presumption of innocence. And nobody is to accuse himself except before the God. Accusare, demo se debet, desi, quorum dio. Nobody is to accuse except before the God. Or demo teritus, ipsum accusare. So, a guilt against a man has to be proved by other men and means. But under the contempt law, which is introduced by the Catholic Church during the Dark Ages, the prosecutor and the accuser and the judge are one thing. So that law is even today in existence, and I have been trying to oppose it on human possible ways. I have challenged the petition related to the Contempt of Courts Act in Kerala High Court, in Bombay High Court. Kerala High Court has dismissed my case, and I filed an SLP against that order. The Supreme Court registry is refusing even to number it. So that is how the system works. So now these things have to change. And one thing I wanted to make, where a judge is unfairly, unjustly attacked, it is a duty of every citizen and every member of every bar to support him. So we are there to protect the judge. A good judge, an honest judge, he does not need any protection.
Exactly.
In Bombay, we have got Justice Vasindar. He left us many years ago. People speak good about him. Good judge, an honest judge. He is actually a judge is worshipped.
Yeah.
A good judge, an upright judge is worshipped. A good judge doesn't require any contempt, any protection because his reputation. See the quality of his judgments. His impartiality. Impartiality is very important.
Yes.
I still remember in Kerala High Court we had a judge in 84-85 period, Justice Kaliyat. See, I always believe he is a saint. Justice Vasindar of the Bombay High Court returned in 2016. He was there as the Chief Justice of Punjab and Haryana High Court. So the kind of respect and affection they commands. So a good judge is worshipped as God. So he doesn't need any protection. No, he doesn't need any contempt. No, he doesn't need any information. The bar knows everything. See, bar, we are interacting. It's an open court. We are interacting with the judges, people, everything. There are no secrets.
Yes.
And in my case, we have created a group of 80,000 lawyers.
Okay.
In NSC, I created a WhatsApp group. So, wherever I want any information about anybody, I get any information.
Exactly.
So now the question is, if it was Varma's money, whose money it was?
That is also a question. That is also a question which is there.
The story going on is that somebody kept the money.
Yeah. Yeah.
At
that was the
Varma's
thing.
house.
Yes.
Varma's house.
Yeah.
Varma's house.
Yeah.
And the short circuit did all the mischief.
Yeah.
Yeah, that was what happened.
Yeah.
So, yes. So now I believe this incident will be not, the judicial corruption is a real
Yeah.
and need to be taken head on.
Yeah.
And lawyers are not daring because, see, we have to appear before the very same judge.
Yeah.
Every order is discretionary. See, lawyers make some money in Article 226 and 32 and 136. That is the discretionary jurisdiction. And other jurisdiction, say, I have a fair amount of civil court work, even this ordinary civil court work I have, because there is no discretion. No, there is X or Y, it is just we are not bothered. But 226, I come to Bombay High Court, I filed a petition under Article 226. The judge says something and dismisses. The next, only the option open to me, I filed a SLP in the Supreme Court, it is dismissed in 93 seconds.
Yeah.
My client has lost his case.
Yeah.
It will be difficult for him to take up the issue for the civil court because they will be prejudiced.
Yeah.
And for a lawyer, if they are not able to deliver this brief, it becomes briefless.
Yeah.
So that is why lawyers are reluctant to speak. And see, there is a principle, Quintilian principle. Many lawyers may not heard of the great Roman lawyer Quintilian.
Okay.
Quintilian is a practical man. He said, you praise the judges.
Okay.
Praise and praise and praise the judges. And get followers in your favor. So,
that is word which is, I think, making Indian judiciary sound.
If you want to be, I tell you a secret, if you want to be a very successful lawyer, make a lot of money, then you adopt Quintilian principle. Be a psychocent, flatterer. Only thing that your self-esteem is lost. But you can make great professional achievements. You can have many Porsche cars.
Yeah.
You can have big bank balances.
Yeah.
But there is something, that is what Saint Paul said. What does it profit a man?
Yeah.
If he has conquered all the world,
Yeah.
but he has lost his soul.
Exactly.
So therefore, I don't practice Quintilian principle.
That is great.
So even if I lost my soul,
Yeah.
what does it profit a man if
Exactly.
conquered all the what does it profit a man if he has conquered all the world, but he has lost his soul?
Yeah.
So even if I'm alone,
Yeah.
many of my friends are not ready to come in the open. They privately support me. I don't have no quarrel with them because they have their limitation.
Yeah.
So even if I'm alone,
Yeah.
I will continue. Not because I have anything against Justice Varma. I am little hesitant because people should not think that something against him. Nothing.
Yeah.
But this is a case that equality before law,
Yeah.
equal protection of law.
Yeah.
That nobody, because of the position he enjoy, should be above law. And Supreme Court often, I've seen courts. I've been in full. They always said, the court, be never so high, the law is above you.
Yeah.
That is Thomas Fuller. Yes.
Okay. Okay.
Thomas Fuller. Be never be so. Ye be never be so high. Never be so high. The law is above you. The law is above you. So all are equal before law.
Exactly.
All are equal entitled to equal protection of law, and therefore the immunity is in the discharge of his function as a judge. Judges enjoy absolute immunity. If a judge pass an order, deny justice maliciously, knowingly, willful denial of justice, also judges are protected, and that is the Judges Protection Act. And it has some historical basis also. From the Roman law also, judges are protected. So there is a maxim which we say,
protection is needed for judges, as you can also,
but this comes from the absolute immunity comes from the classical Roman law. I know quote a Latin maxim.
Yeah.
De fide officio judicis non reci pete questio licentia save sit error juris save facti. D means about the honesty and integrity of a judge. No question can be asked.
Okay.
But about licentia, about his knowledge, and the correctness of his judgment on facts and law
Yeah.
can always be questioned. So it has the immunity, concept of immunity.
Yeah.
Judicial immunity comes from the classical Roman law more than 2000 years before.
Yeah.
And I believe it is Cicero was asked if judges are there are no questions about the integrity or honesty that can ever be questioned. Then what is the solution if a judge willfully delays justice?
Exactly.
Then-
After all,
then-
a judge is also a human being.
No, then Cicero said, Ab alias acta, altori code fesaris. Ab alias acta, when you reach the heavens, the Almighty will ask you. So that was the concept. But that is today that Almighty is answerable to the Almighty. Of course, he is answerable to the Almighty.
Yeah.
That alone is not the solution. Our law should also provide for a mechanism for
Exactly.
making the judges who willfully deny justice in the discharge of the judicial function accountable. And that is why we led a judges accountability bill, which was laid by, I believe, none other than Kapil Sibal. So, yeah. Thank you.
Thank you so much, sir. And hopefully, as you said, you will be approaching with the FIR. And
Yes,
one last question and a crisp answer I want from you is how you see government's response to that. We had the inquiry and the inquiry happened, everything happened. Now, where's the accountability? Most of people are just questioning that where is the accountability? What will
I'm answering
happen
that.
if you don't file the FIR? What
No,
if you
yeah,
don't file
no.
an FIR? What's next?
No, the problem with the government is, see the government with the PIN, everything under the sun is justiciable. The courts assume the role of the parliament, the executive, the supreme parliament, supreme legislature, executive all into one. A court can put the government into great extreme embarrassment. I tell you one instance. When on 14th of May 2020, year I forgot, when the BJP lost Karnataka election, Kiran
Okay.
Rijiju, it's been 4 days. On 14th, BJP lost the election. On 18th, Kiran Rijiju was removed from the law ministry. He was a law minister.
Yeah,
He was saying what we were saying. And many of the MPs are in our WhatsApp groups.
Okay.
Okay. And therefore BJP, the government in power cannot displace the judiciary. Judiciary can cause real difficulty.
Okay.
And that is not about BJP alone. When Manmohan Singh was the Prime Minister, because I know some of the MPs, they took up the issue of judges accountability and other. Then Manmohan Singh said, no, we cannot afford to displace the judiciary.
Okay.
So, see, Manmohan Singh also, therefore, be it whether it is Congress, whether it is BJP or some other form of government in existence, so long as through the PA, the judges, through the PA, which is they enjoy, I say against the constitution, so much of power. Political, then no government in power can speak utter a word against the judiciary. The judges can put them in a great difficulty. A lawyer like me can speak. What the court can do against me? Nothing. Only thing is holding me in contempt.
Yeah.
But I don't think anybody will find it profitable to hold me up for contempt, because to paint me in the dark, they are glad to paint themselves in the dark.
Yeah.
So, I have court proceedings, I am video recording, I am circulating.
Okay.
It is not me who has to correct it. The court has to correct, because there is a right, there is a duty of right to rebellion. This is Matthew's book.
Okay.
It comes, even Jesus Christ
Yeah.
violated Sabbath,
Yeah.
and Buddha did it. And Saint Augustine, there's a lex injustitia known as lex. Unjust law is no law.
Yeah.
Lex injustitia known as lex. And unjust law is no law. That is Saint Augustine, the great jurist. And the greatest jurist, Thomas Aquinas. Because Saint Augustine, Thomas Aquinas, because the Supreme Court has quoted ever so many times. That's a great jurist. So there's a duty of disobedience.
Yeah.
And I always am a great fan of Justice K.K. Mathews. I consider him the greatest of judges. Unfortunately, many lawyers and judges, many people or common people, even educated people, they also are not much heard of Justice Mathews. But his book, read his small book.
Okay.
Three essays.
Okay.
And one of the chapters is Right to Rebellion.
Okay.
There is a duty to disobey and question unjust law.
Okay.
Lex injustitia non est less. An unjust law is no law. You have a duty to disobey. Right to rebellion.
Right to rebellion.
Thank you.
And with
Thank
this
you.
note, thank you so much, sir, for joining us on this important matter,
Yes.
which will supposedly
Yes.
be still a mirror to Indian judiciary system, and will be a mirror to Indian judiciary system, and will keep the track on this case, and will see how the government or the system, both the judicial system and the executive system, perform on this case. Thank you so much.
Thank you, ma'am. Thank you, ma'am. Thank you,
Okay,
ma'am.
okay.
Thank you. Thank you.